Can a man reproduce after his death? And for this, can he preserve his semen to be used after his death to continue his generations? This question came before the Delhi High Court. And to understand this, we will welcome today Senior Advocate Suruchi Aggarwal, who argued this case in Delhi High Court and assisted the court with the legal and ethical issues which raised in that case. So we feel blessed, ma'am, to invite you on this channel.
Thank you so much.
And I come to know that you are also contesting for Delhi High Court Bar Associations in the category of senior designated senior lady. So I extend my best wishes to you first of all, and I wish you all the best for that.
Thank you, Mr. Madhav Prakash. I would first of all like to say that this issue arose because a couple came to me whose son had died due to an aggressive form of cancer, and they did not get much time after discovery of the disease, but they were able to persuade, and the son was willing to preserve his gamete sample for posthumous reproduction. Now, this implied a consent on the part of the deceased. So the parents were desirous of continuing the legacy because he was the only son, and therefore, when they approached me, it was a situation where even I was caught up in the ethical conundrum as to whether this should be argued, this should be taken up as a cause or not. So when I read the judgments on the issue from world over, and especially the case of Hecht versus Superior, which is a case of Californian Appeal Court, where this issue exactly arose as to whether there should be posthumous reproduction and one should allow giving birth to a child where none of the parents exist at the behest of a grandparent. Now, the view taken by the appellate court in California in this case was that this was not the subject matter of value judgment by the court. It is for the parties to decide what they wish to do in their personal lives. And this is what has influenced the Delhi High Court also in coming to this conclusion that the grandparents would have heritable rights because the son had died intestate and without a spouse. So it is for this reason that the sperms, the gamete, which were preserved with the hospital, were treated as a property belonging to the deceased, which was heritable by the grandparents. This is what we had argued, and this was what was held.
It means it is a property, and through a will it can be transferred to anyone.
Yes.
And if there is no will?
In this case, I'm interrupting you, I'm sorry. In this case, there was no will in this case.
Okay.
But because he had died intestate, and the only available heirs of the deceased were his parents, because he was not married.
And there was no wife also?
There was no wife.
So one question which is coming to my mind is, if there is no wife, and even if the same is been through consent of that man also, is inherit to the grandparents. So how can it be used, because the wife is not there, number one. Number two, the surrogacy will not be legally possible in this case, because for surrogacy the intended mother cannot be given any consideration or any payment for the same. She should have willingness to do so. In most of the cases it is seen that she is the relative, and out of love and affection she does so. So how in this case you satisfied the High Court that after releasing the preserved sperms to the grandparents, it will be used in surrogacy or at any other thing legally?
Let me tell you one thing, Madhav. First of all, the ART Act was not specifically applicable to this case. Neither was Surrogacy Act applicable in the present facts and circumstances, because before the coming into force of the Act, immediately prior to that, we had already moved the High Court, and the son and the deceased person had died in 6 to 8 months prior to the coming into effect of the Act, and this action had already been taken. Therefore, the court was of the view that the ART Act does not specifically apply here. But to your question, what I'm answering is what the parents intended to do was that they plan to undertake surrogacy with a relative. So there is no consideration paid in this case.
Very nice, very nice.
And I had given an undertaking to the court that we will be complying with all the laws in this.
If the child is given the birth, he is brought in the life. By birth, he will be an orphan. So because of fulfilling someone's wish, should we play with a new life? Because in every situation, keeping the financial position constant, a child with both the parents alive will always be in a better position than an orphan. So how, and when he has to choose his career options, will he be focusing on his career on the health condition of the grandparents, because the life will be challenging. So how do you see this, not as an advocate but as a lawmaker?
You have a point there that the parents of the deceased were in the late 50s and early 60s. The deceased father was in the early 60s, and by the time, if at all, this fructifies and the child is born with undertaking the process of IVF, the parents of the deceased would be considerably old. But in this case, let me inform you, the most interesting part was that even the sisters of the deceased were undertaking to look after the child.
Very okay.
The entire family was so deeply involved with the legacy aspect that I was also carried over. And that is why I took it up as an assignment and I took it up as a cause to bring justice to them, so that because they desired to carry forward the legacy.
So the main purpose was to continue the legacy, to continue the generation. But in your opinion, I am asking, isn't this approach dangerous also, because few years back people were of the opinion not to have daughters, just to have sons, because son will continue the legacy.
I put this question to the parents of the deceased. Let me tell you, when I take up a case, I take it up with responsibility.
Yes.
And I have spent at least, if not to say less, but at least 10 hours with the parents, discussing with them as to how things will shape up once we get a judgment in our favor. And this was prior to putting my energy on research and to take up the issues that arose before us. Okay. So I was quite satisfied that they were not merely looking for a son as the legacy.
No, not as a son, but this approach.
Despite the fact that they have two daughters,
Yes.
they are willing to have another daughter, because nobody can take a guarantee that the legacy would be only a son in this case. It could have been a daughter.
It could have been a daughter.
They would have welcomed the daughter with open arms.
But yes, I want to understand that mentality of the parent, the grandparent, or in any other case also, that if a daughter is born, she will.
Let me tell you one thing. This is not the case. They already have two daughters. And that is why I was worried that if another daughter is born out of the sperm of the son, then what are they going to do? How does the legacy carry forward? There I want to correct you. The legacy in this case is not merely a son.
Legacy, but the daughter
case,
will increase the legacy of some other family.
No. In this case, they wanted the gamete to reproduce so that what you call the ansh of the son is with them. I have no English word to express this, but वो चाहते थे कि उस लड़के का बच्चे का अंश उनके साथ रहे.
That was the emotion.
That was the emotion.
And the High Court has laid down this law.
Yes.
That this posthumous reproduction is, so there is no bar on it.
There is no bar on it, but let me clarify, there is a rider. In this case, the ART Act did not apply.
Yes, it was before the enforcement of that act.
Apply on all fours. It was before the act came into force that this incident has already taken place.
This is a big rider right there.
Yes.
So in the end, just one thing, with your experience, would you like to give some message to new advocates or litigants or the society at large or the lawmakers? Any message through our channel?
I do have a message for the youngsters who come in, and that is that there is nothing which can surpass your passion for a particular cause, your passion for your work, your hard work. There's nothing which will surpass it for your success.
I once again wish you all the best for your upcoming Delhi High Court Bar Association elections.
Thank you so much. Thank you.